You may be seated. Good afternoon and welcome to Division 6 of the Court of Appeals. I'm Judge Welling, and with me on Division today are Judges Yoon and Lum. This is the final sitting of this configuration of Division 6. This is a rain out or snow out of our courts in the community case. We do sincerely appreciate counsel's willingness to participate in this case in courts in the communities, and we and the students were very much looking forward to it. But with that said, I do see we have experienced counsel. So does anybody have any questions regarding our oral argument procedure?
I do not, sir. Thank you.
Okay. The one thing I would remind everybody of is that these arguments are being live streamed and archived on our website. So please be sensitive about that with respect to confidential information, including victim information in this case. And with that said, we will begin, Mr. Steinberg, for the defendant.
Thank you. May it please the court. My name is Harvey Steinberg, and I represent the appellant. And this case presents some interesting issues. I'm going to suggest to you that, to begin with, we have a situation where the police took, if you will, great liberties in utilizing the house as basically a staging station. They were in and out of the house constantly, and there were numerous officers. And there was no attempt, and the record confirms, to obtain consent from anyone really to come in and out of the house. Secondarily, it's a little different than most cases you see because the defendant in this case was placed into what the court found, the lower court found, was protective custody, I believe, between 12:53 and 1 a.m. And the court found...
Actually, till 3 I thought it was until 3 a.m. that
he was arrested,
but he was placed
according to the court, at 3:19.
Right.
So what's unique about this, you have a situation where someone's in cuffs for over 2 hours, and yet the district court found that the arrest didn't take place until 3:19. The other thing that is somewhat unique is, and it's in the court's order itself, is the protective, if you will, sweep takes place, I'm going to suggest to you, about a half hour, 35 minutes after police arrival. That is different.
Do you know how long it was after the victim had been taken away in the ambulance?
I think it was shortly thereafter. Okay. I shouldn't say that shortly, because as I recall the record, I think the record will reflect the medical personnel had arrived prior to police. Mm-hmm. They were waiting for the police to escort them in. The police escorted them in, and then shortly thereafter, the victim was removed and taken. I would suggest to you, if we agree that we're talking 35 minutes before, if you will, the protective sweep, then I'm going to, in answer to your question, suggest that it was at least 30 minutes after she had been removed.
Okay.
And there was some controversy, if you will. I actually did the motions hearing, and there was some controversy as to whether or not Officer Brown or Deputy Brown, who was the first officer who arrived, conducted a protective sweep.
I do have a question about that. Are you arguing in your briefing that the trial court erred by finding that he did not conduct a protective sweep?
You know, it's a two-way street, and let me tell you what I mean.
Okay.
I'd like to say yes, because if we have that, Deputy Brown doesn't find the significant evidence that we believe should have been suppressed and should be excised from the affidavit. Because if Brown...
What evidence did he find?
Didn't find anything.
So what does it matter? Is it harmless?
No, because you don't get to do two protective sweeps. Clearly, if you find, as we argued earlier, that Brown conducted the initial protective sweep when he first enters into the location, he goes downstairs, and here's the key. After going downstairs and finding the victim, and she's then transported, he goes back in with his flashlight and says, I went into a bathroom because the door was open. And he confirms that no one's in the bathroom. So one could argue easily that, and I'm giving this concession to the government, that his going downstairs initially to look for, if you will, the victim is attendant to an exigent circumstance looking for the victim. But when he has found the victim and she's been removed from the scene, and then he goes back into the house because he says, I see an open door, the purpose of that is only for a protective sweep to make sure that no one's in the bathroom that could pose danger to Deputy Brown or other officers who are now on scene.
But couldn't there be, okay, let's say that we agreed with you that that was a protective sweep of one room of the house, the
Yes.
bathroom. Couldn't there be other locations in the house that could still pose the same danger and justify a protective sweep that was conducted later?
That's a compound question, and
Well,
I'm not
allowed to ask
objecting.
those.
So let me tell you, the answer to the first part is yes. I think that that's fair. The answer to the second part, when you use the word justify, is no, because what additional information did they have? What did they possess?
Well, the information that they possessed as articulated and as I think found by the court is they didn't know who the shooter was. Nobody was telling them who the shooter was. There were more cars there than people. There was more food there than people. The gun that was actually used to do the shooting was still unaccounted for.
They don't know that.
But they
Keep in mind, they searched my client.
And they found a gun.
And they found a gun. There's no way that they have the ability to say that wasn't the gun that was used. It's only afterward when there's, if you will.
But that gun hadn't been recently fired, and this is a fresh shooting, right?
Fair enough.
So they found your client intoxicated with a gun, but
Yes,
not
sir.
the gun that was used.
But-
And nobody is telling them that this is he did it or that that's the gun.
Great.
So,
So what we're doing is I forget the word. As you get older, you forget words. But the word I'm thinking of is you're melding, I suppose is the best word. And you're saying, hey, we're going to be able to search for evidence. And we're going to couch the search for evidence in a way to say, hey, it's a protective sweep. Because everything you said says, hey, the defendant has exercised his Fifth Amendment right. He's not talking to the police. And we have a situation where we got to find this gun. So we're going to go search the house without probable cause.
nor is
because
anybody else. I mean, there's.
But you don't
I'm sorry,
have.
Mr. Schreiber.
I'm interrupting you, and
Yeah,
I shouldn't
no.
do that. I apologize
No.
to you. Sir.
Go ahead.
So you got to take that next step, and you got to say, okay, under Bowie, they have that magic language. They have to be able to say that there's a person who's posing a danger in the house. So what you have here is, well, there may be somebody. We don't know. That doesn't fit Bowie, and we know that that's what the judge found because in her order, she specifically says, when she talks about the facts, she says, quote, and this is at page 2 of her order, Deputy Russey's did the, if you will, his body cam, excuse me. The officer in charge of the scene, Russey, to conduct a protective search. When asked if they had everyone at the house accounted for, Corporal Bach stated he thought so, but would not be confident that he had everyone. So how does that jump to a feeling, well, somebody's in there that's going to attack us when you don't even know? You're speculating and you're saying, I'm not sure. Why don't you go check? How does that rise to the level of the fact that you have to, under Bowie, be confident, if you will, to use a term of art, to suggest that there's somebody there who poses a danger to us, especially in light of the fact they knew everybody there was law enforcement. So you don't have a situation where they're...
Do we know that they knew that at the
Oh,
time?
yeah. They had established in terms of their interviews that this was a law enforcement party to celebrate somebody achieving success.
Does that factor in here? I mean, and
Of
how does it
course.
cut? Because now you actually know that in all likelihood, all the attendees at the party are armed and there's been a crime committed.
And sworn officers of the law, and we don't know for sure there's been a crime committed. We know somebody has been injured, but we don't know there's been a crime committed. And it seems to me that I can distinguish from if I go to a party and it's a party where they're, if you will, gang members, and they're known gang members, and they're gang members who have a history of, if you will, assaulting police officers. versus being at a party where they're all law enforcement officers, that's a distinguishing factor, and that's a fact that's important, I think. in
Give me
terms of-
give me a case that establishes that's an important factor that we should consider.
Well, I'll get to it, but common sense in terms of all the factors. I'm at a house.
So there are different Fourth
Where's
Amendment
Hell's
rights
Angels?
for. Okay.
Yeah, I'm at a house where there's Hell's Angels. Hell's Angels are known to, if you will, assault police officers versus a law enforcement. I mean, that I'm going to suggest to you that's fairly common sense. That if I'm a law enforcement officer, my level of comfort's going to be different if I'm at a party with other law enforcement officers versus a Hell's Angels party.
And it was Bach that was the commander on scene that ordered the protective search. Is that right?
Yes.
And he's not the one that said that he was pretty confident that everyone had been accounted for. He asked somebody whether everyone had been accounted for, and he was told, yeah, probably, and it didn't instill confidence in him, is my recollection. And therefore, Bach's call, from the information that he gathered, was that everybody wasn't accounted for.
Well, that's not what the district court found. This is at page 2, and I'll read it. When asked if they had everyone at the house accounted for, Corporal Bach stated he thought so, but would not be confident they had everyone. He thought so. So how does that ever rise to the level of we got somebody who's dangerous who could cause harm to us? I don't think it rises to that level, with all due respect.
Okay. Before you run out of time,
I still have 5 minutes to
okay,
talk
well,
to you.
Excellent. If we were to find that this search was unconstitutional and the gun should be suppressed, what charges get reversed?
Well, one for sure, because one of
That's the second drunk with the gun that they found.
because that's in the instructions. It particularly limits this gun. So
Okay.
that's clear. And the second thing is I'm going to suggest you have to do all of them, because in terms of how the case was tried, the case is tried with the fact that we know that they're going to present evidence from a DNA expert that has the defendant's DNA on the gun. They're going to say this is the gun that was used to, if you will, conduct the shooting. And the gun, if you will, was secreted, for lack of a better term.
But
So
he was found and searched, and the gun was found on him before the protective search.
yes, sir.
And he was intoxicated. The
Yes,
search
sir.
didn't change whether or not he was intoxicated.
No, sir.
And there were several witnesses that also testified at trial that he was the shooter, correct?
Who were drunk as a skunk, and in terms of cross-examination, a different approach would have been taken. You can't, in terms of the defense and the strategy, go after the witnesses who were completely intoxicated, all of them drunk as skunks, and some of them saying, I don't know, some of them saying yes. You have to take a different tack when it comes to that, because you got a DNA and you got a gun expert who's going to say this is the gun that did the shooting. Without that, I'm going to go after those witnesses and say, you can't be sure, you don't recall, how much did you drink, where were you? All those become factors in terms of strategy.
So you're saying criminally negligent. I don't know if it's third degree.
It's third-degree assault.
Third degree assault and
That
one
negligent
count
use of a weapon.
of drunk with a gun.
The drunk
and
with the
rec-
gun is tougher. I got to concede that.
Okay, so
because
the-
they do a pat down on him
Okay.
outside, and they find the gun. I'm going to take a little license and say I still could have argued it, but it would have been, that's a tougher, it's a much tougher road to hoe.
All right, let's not get. I just wanted to get your position on that because
Yeah.
the Attorney General emphasizes that that we can avoid this whole issue because of.
They can't, clearly, because one count deals exactly with the gun that was improperly and illegally found. So you can't, you have to reverse if you find that the search was illegal. There's no
What about
choice
the
on that count.
independent source doctrine that they raised? Independent source?
I don't buy that doctrine, and here's why.
As a doctrine, or in this case?
No, as a doctrine, I'm saddled with it.
Right. That's why I was curious what your
Yeah.
was.
So I'm going to suggest to you the problem with that is that we don't know if they would have gotten a search warrant. We don't know. I hate the speculation. This independent source stuff is always speculation. What would you do? I mean, if I were a trial judge, I'd
That's the
probably
nature of the
sustain.
doctrine, isn't it?
Yeah, but I think that usually I like to say you have other people planning to do things. Keep in mind, they're at this place for 2 hours before they arrest my guy. The cops are running rampant, and it goes back into my argument. This isn't a protective sweep because before they conduct this protective sweep, the cops are all over the house. There's multiple police officers walking in and out at will. It's become a substation for the Douglas County Sheriff's Office before the protective sweep.
What's the relevance of that?
Because it goes to whether or not they really thought someone was going to hurt them when they're using this as a, if you will, substation, and police are coming in and out at will without an attempt to get permission. And now you're going to tell me, oh, we thought there was somebody there that was about to launch an attack on us? I have 1 minute left. Should I save it?
We'll give you a minute of rebuttal.
Thank you.
As best I understand the argument is the biggest concerns about this as a protective sweep is he wasn't arrested at the time.
Right, and that's irrelevant because of...
I mean, that you contend that it needs to be subject to an arrest, or it needs to be incident to an arrest.
Under Bowie, there's two. One, you can go into rooms adjacent to, attendant to an arrest. You can't do that here because the arrest is 3:19, hours after.
So we've got, he wasn't arrested, that he was arrested, that when he was detained, it was outside the home and the sweep was inside the home.
Yes.
And that there was the delay between are those the big issues that you have with this search?
And they really can't articulate why they thought that even if they hadn't accounted for everybody, that people who they hadn't accounted for were going to launch an attack on them. That's pure speculation. There has to be an articulable fact that says these guys are Hell's Angels. They routinely attack cops. They hate us. That would be something. That's why that's relevant. Versus these are other cops.
And the go ahead.
What if they were neither cops nor Hell's Angels? Like, what if they just didn't know who these people were?
Not enough.
So is it your position that the police have to have some suspicion, not just that there are guns around or could be other people in the house, but that these are the type of people who would attack cops?
From my position, Bowie says they have to have articulable facts that suggest there's somebody who's in hiding is about or capable of launching an attack on them.
But capable of launching an attack is going to launch an attack because these are the types of people who are here. It seems like that's more, physically capable of launching an attack.
I disagree with that because under that theory, we're going to be able to search anybody who exercises their Second Amendment rights. So if you go to a house and you say, oh, this guy has exercised his Second Amendment rights, he has guns in his house, now we're going to go do a protective sweep versus somebody who is an anti-gun advocate who never's had a gun in his life. I don't buy that.
This isn't we suspect that he's armed. This is a person has been shot and we don't know who did it or with what weapon.
Well, you got some problems with that because the police obviously find a gun on the defendant, put him in handcuffs, and he's offered no resistance. He's no suggestion that he's going to do anything, the police. They must have thought that he was either dangerous to them or that they were very close to achieving probable cause to arrest him. Because why do they hold him for a half hour in that situation before they conduct the search?
Okay, and Bagley characterizes the Bowie circumstances in kind of two buckets. You've got you can look in closets and areas immediately adjacent to where the arrest or confrontation is, and you don't need to have that kind of articulable suspicion. You can just check closets and do that. But once you start to go beyond that, you need to have articulable facts that you are subject to potentially some sort of an attack. Is that fair?
No, because I want to add this. I think Bowie, in terms of the first bucket, talks about the fact that it has to be at about the time of the arrest. Keep in mind, the court found that the arrest didn't take place till 3:19.
That also assumes that it needs to be incident to an arrest. And I think Bowie was incident to an arrest,
yes.
But there are a number of cases from around the country that talk about it not being confined to those circumstances. It's not a necessary factor. This is not a search that is only incident to an arrest.
I agree. There are some cases that they stray from Bowie. But the theory behind Bowie and the spirit behind Bowie is when officers are conducting an arrest of someone and actually physically putting him under arrest, the heightened danger is there emotionally, and also because they're worried about, their attention span and their attention in terms of what they're doing. So that's why there's the two distinctions. I think you're distinguishing it and saying, hey, look, you can expand the search, which is true, but to expand the search, you have to have articulable facts that say, hey, he's under arrest now, but there could be somebody upstairs
Right.
that has that gun, and we got to go find him because he's about to launch an attack.
Do you have any cases that have expressly confined the protective sweep to being incident to an arrest? I know you say that Bowie does that, but
There's two. I shouldn't say there's two cases. There's two ways to do it. In terms of Bowie does not confine it incident to an arrest. As Judge Welling said, there's two ways to do it. One, you can go into closets, anything you want that's nearby, if you will. The protective sweep, the second portion that allows you to go outside what I'm going to call the circle of arrest, if that makes sense.
Sure.
Then you have to have this articulable suspicion. And it doesn't have to be right at the time of the arrest because it can be launched as you're walking them out, etc. I'm going to suggest the first Beckett requires, although it's been some cases expanded it, none that I've seen in Colorado or the 10th, suggest it has to be within seconds or shortly after the arrest. The second bucket, I think you can do if you have the ability to take the person out, etc., etc. But that requires articulable suspicion. It's not, I'm thinking Bowie has the old law, search incident to an arrest. You could search anyone in that area, what I used to call the grab area. Bowie said that's what we do for protective sweeps, the grab area, but we're going to expand to closets where somebody could be behind a door and jump out at you. Then it comes up with the second one, because we're talking about a person's home here. It's the last sanction we have.
okay, and so I just want to be clear on what you're saying. What you're saying is that this all took place within the second bucket, right? That
Yes.
expanded area.
Absolutely.
And that second bucket could be incident to an arrest or not, but it needs to have those articulable facts. That's what you're saying.
It can't be incident to an arrest because the court found he wasn't arrested until 3:19 a.m.
But as a matter of general rule.
Yes.
Okay.
The answer to your question is yes.
Okay, thank you.
So an arrest isn't, you agree that for the second bucket, arrest isn't necessary?
Absolutely. You're absolutely correct.
Okay.
For the second bucket, you don't need an arrest.
Okay. And,
So-
okay, go ahead.
What's the standard review on finding whether or not there's articulable suspicion?
I think it's.
You make all these factual determinations.
I think that you're tied to the facts, but I think it's de novo in terms of the law.
the legal conclusion.
Yes.
But the findings of fact, I'm sure counsel's going to get up and point to other facts.
Hopefully not.
Okay.
Thank you.
Thank you, Judge.
Ms. Morales.
May it please the court, Carmen Moraleda for the people. My attorney registration number is 34852. There's a lot to explain. Let's begin by the Bowie standard. I think we agree that we're on the second bucket, right? And which is simply that under Bowie, police can look in any places when they have specific articulable facts that support a reasonable belief that someone dangerous remains in the house. And this only needs to be incident to an arrest, which means contemporaneous, can happen before or after. What the court found
Does it
here,
need to be incident? I thought that.
I believe so. I believe that it has to be incident to just the Bowie standard as laid out in that specific opinion. Other courts have extended it, but in this case, I think the court found that it is a little bit unclear because the formal arrest happened at 3:19, but Mr. Defendant was placed in protective custody at 12:53, which to me is the functional equivalent of the arrest for Bowie purposes.
Does it matter to our analysis?
It doesn't matter. All that matters in this court for this court purposes is that the court found with record support that there were specific articulable facts to support the reasonable belief that someone dangerous was in the house. And let's just quickly summarize those facts. Police did not know who the shooter was. Police did not know how many shooters there were. Police, there was evidence that other people could be around based on the cars parked outside, the food, the drinks, the guns that were visible in the cars, and also the fact that police have been informed that the gun used in the shooting was the 1911 Colt. So they knew that, and when they once defendant was put in protective custody, he had the revolver.
Who was told that it was the 1911?
There is evidence in the record to support that the gun that was used in the shooting was the 1911.
No, but my understanding is that information prior to the search came from somebody outside the home before the officers entered, and I'm just wondering which officer was told that they suspected it was a 1911.
I don't think that is clear from the record, but it's
Okay.
someone was told that that was the gun that was used. And kind of what triggered there, because the defendant had, again, the revolver and then the magazines consistent with that 1911, in addition to the holster who was in the defendant's girlfriend pocket.
Who needs to know the set of articulable facts that support doing the expanded, the second bucket buoy search?
Well, I would think in this case would have been Officer Buck,
Okay,
because he's the one who ordered it.
That's why I'm asking.
Yes.
If another officer was told that it might be a 1911 and that wasn't communicated to Officer Bach, is that an articulable fact that can support the protective search?
Yes, it doesn't matter. That's just one fact. You have to look at everything in terms who else can be there that is dangerous and can have a gun.
But I don't want to just take all of the possible facts
Okay.
that could potentially support a buoy search and just say that these are facts that exist that could support it. These need to be specific, articulable facts, and as I understand it, because I think I agree with you that it's buoy or it's Bach that has to know them. So if other officers have other facts but they're not communicated to Bach, how can they be articulable facts that can be considered to conduct and to support the search?
Well, the answer is that Buck had enough articulable facts or enough to conduct to
What did
request
he
facts.
know?
What did he know?
Yeah.
He knew that they didn't know who the shooter was. He knew that he knew that they did not know how many shooters there were. I believe he also testified that he knew the gun that had been used had not been found. And also he had information because when he got there, he saw many cars parked outside. So he knew there were more people or evidence of more people than just the people who they saw once they entered the house and went into the backyard. So he himself had all that information to justify the protective, especially when he asked Officer Dobbs about the protective sweep, and he said, as far as I know, on the lower level, but really not on the first floor. So he said, that didn't make me feel confident that one was conducted and that we were safe.
And that gets in, that kind of cuts both ways, because the lack of feeling confident and having an articulable basis for it. And I guess I look to, do you have any issue with the way that the 10th Circuit framed it in Bagley, and I think it also was relying on Nelson?
Bagley?
Yeah, because Bagley, they said, your general suspicion that there might be other people there isn't enough for a bucket 2 search or protective sweep. And do you take issue with the legal standard and how it was framed and has been framed by the 10th Circuit in Nelson and Bagley?
So I believe that Bagley is factually distinguishable because in Bagley,
I want to wait to get to factually distinguishable.
Yeah.
Do you think it got the law right? I mean, because we're not bound by
Exactly.
by Bagley. So I want to know, as a threshold matter, do you have any problem with the analytical framework that the 10th Circuit has been operating under?
I don't think so. I just think the way they apply it to the facts, it kind of supported their conclusion. In that case, again, there was absolutely no facts, no articulable facts to support that anybody else dangerous was in the house. They had an arrest warrant for defendant. When they got there and they took defendant out, and I believe the girlfriend, again, there was absolutely zero evidence that anybody else could be there, unlike our facts.
Well, they didn't know. What it emphasizes is they didn't know one way or the other.
But we did know in this case. I mean, we did know we have evidence that other people could be in the house. And I think that's the distinction in this case.
Just other people in the house? But don't the other people in the house also need to be a threat?
a threat. Well, the threat was that the police were called to a shooting. Okay.
Right?
And they saw many cars outside. Again, all the facts that Your Honor has recited, and I think that was enough. I mean, Bowie doesn't require confidence that there is actually someone with a gun. It's just a reasonable belief, and I think that's.
Is that the standard? I mean,
That's the standard.
I'm looking for a term of art because, and the reason I'm pressing you on this so
Yes.
hard is, as best I can tell, we don't really have any protective sweep case law
Yes.
in Colorado. We're looking to other jurisdictions and
Yes.
and the federal courts, and this to me presents some borderline facts as far as not having a protective sweep end up being a pretext for a search for evidence. And I'm trying to figure out how, if we say this is enough, but also say we agree that in Bagley it wasn't, what's distinguishing it, and particularly where the officer, the commander on scene that ordered the search did ask, do you think there's anybody in there? And he's gotten information that says, no, probably not. And what that does is instills a lack of confidence in him. So why doesn't that put it, that particular piece of information, put it more with Bagley, that don't know one way or the other, but gee, it's better to be safe than sorry. And as I read Bagley and Nelson, better to be safe than sorry isn't enough for a protective sweep. It needs to be more specific than that. And am I right or wrong on that? And why does this support going that way?
So, in Officer Bach testified that he asked Officer Dobbs, has a protective sweep been contacted? And Officer Dobbs expressly, said, not of the upper level and of the lower level, as far as I know. But it wasn't about, is there anybody inside or not? That wasn't the question. So that prompted the officer to say, we need a protective sweep because I don't think one has been properly conducted. So that's the testimony of Officer Bach. Okay, I don't think that the Officer Dobbs said, I don't know if there's anybody inside or not. That wasn't what occurred in this case.
Did the court? Mr. Steinberg seems to indicate that the court found that was the case, that he thought that.
I don't think so, and I don't know if I'm gonna find, but in reviewing the trial court order, I think the court might have confused the names of the two officers in terms of, because it was Dobbs who told Officer Bach, I'm not, as far as I know, but.
What do we do with that so is that a clearly erroneous factual finding that Bach said that, as opposed to Dobbs saying it to Bach?
I don't believe so, because in the end, what matters, I guess, in terms of the factual findings, is that the Bach's decision to conduct or to order to conduct is supported by all the totality of the circumstances, the things that the officers were encountered when they were there. So that's, and again, I think that the trial court might have confused the name of the two officers. I can,
Okay.
but I'm not going to find it.
Do you agree that the delay between the officer's arrival and conducting the protective search is a fact that cuts against you? No, and so just let me give you a quick timeline. So the 911 call was placed at 12:17. Officer Brown, Hondorf, and Dobbs arrived at 12:28, just 11 minutes after. So Officer Bag, Rusi, Brito, and Maracin arrived at 12:50. Mm-hmm. Okay, and at that time, Officer Bag testified he saw the ambulance leaving. Right. So this is like an evolving situation. This is not like a scripted, right? So when Officer Bat arrived, shortly after he arrived, he asked for the protective sweep. So the fact that it's 30 minutes is kind of different because you have two different set of officers who arrived and encountered different things. The priority. Let me phrase this differently. had the protective sweep been done immediately upon their arrival, do you have a stronger or a weaker case than if they wait a half hour?
Okay, so as the prosecution argued and the court found, I don't think that just entering the house to get to where the victim was a protective sweep. Okay, they got there. As I argue in my brief, there was consent. Police didn't just show up. They were called to the scene because there was an emergency, a shooting, and an injured victim. So they called, the person opened the door and told them how to get to where the victim was.
Right.
The fact that they were just flashing their flashlight briefly didn't turn that into a protective sweep.
I'm not asking about whether or not this ends up constituting a second protective sweep. I'm just asking about the fact that it was ordered a half hour after they had arrived. It isn't a stronger case for a protective sweep more proximate to the arrival of law enforcement? Isn't that a factor that would be in favor of finding it a legal protective sweep?
Well, yes and no, but just remember, Your Honor, that when they got there, the priority was to render assistance to a shooting victim.
No,
That was
I
the
understand
priority.
that. That's one of the
was
reasons.
priority.
That's one of the reasons I asked the question about what was the time differential between her being taken away and ordering of the protective sweep.
But I have a second thought, and I haven't argued this, but even if that was a protective sweep, just the entering through the house, the second protective sweep was reasonable too. There's nothing in the law that prohibits two protective sweeps as long as they're reasonable. And in this case, both would be reasonable.
Mr. Steinberg, this is not a trial court. You don't get to object. You have a rebuttal. But the delay of time here, and if there had been a first protective sweep and this is a second protective sweep, it's not limiting the number of protective sweeps, but it is having a reasonable articulable suspicion that there is actually somebody that is posing a threat and not just a speculation of it. And why doesn't the passage of time, and particularly the officers going in and out and going through the house safely, indicate is a factor against this being having an articulable suspicion that there was a specific threat that was posed?
Let's agree that there's one factor that cuts against it, but you have to look at the totality of the circumstances.
That's all I was. That was actually the point I was trying to see. Do you agree that is a factor that cuts the other way?
It would, but on the other hand, if you're talking
Can I ask, when did the police know that they didn't know that there's a possible unknown shooter? Don't they have to do some investigation before they know that there might be a third party that they haven't apprehended?
So all they knew is that someone has shot somebody else, but they didn't know for
When did they
sure.
talk to the defendant?
Defendant didn't help them. Defendant didn't say it was me, but it was an
When was
accident.
that conversation? I'm sorry. I'm
When
just
was
trying to
that
get the
conversation?
Yes.
It was when, at the time, he was. He never said anything about who was the shooter and why.
I'm just trying to find out, when did they speak with the defendant?
So this would have been 12:50. No, yes, 12:50. They got to agree. No, pat it down to 12:53.
12:53?
Yes.
The protective suite when?
And I think the protective sweep started at 1 and ended at 1:12.
Okay.
And may I have a little bit extra time? Apparently, Officer Rusi's video cam, which is not in the record, I think it was 30 minutes. And the trial court relied on it to find the sweep legal based on what the officer did, but we don't have that in the record. So this court must assume that the court's ruling was correct because we don't have that video cam. If I could have, since you allow Mr. Steinberg a little extra time, because I would like to flesh out my harmlessness argument.
Great. That'd be great.
Okay. So my argument, and I'm sorry that wasn't more specific, there was overwhelming evidence that it was defendant. Several witnesses testified it was defendant who was drunk, and it was defendant who shot his gun and shot the victim, right? And even defendant conceded that he was negligent, intoxicated, and had fired a weapon and caused bodily injury. So there was two specific witnesses who testified that they were pretty sure, at least one, that the gun the defendant fired was his 1911. One of them was very friends or with the defendant, and he knew the defendant carried two guns, the revolver and the 1911. So that was his testimony. And another witness also testified, kind of corroborated that it was semi-automatic, not a revolver. And in addition to that, there was evidence that, the magazine pouches found on the defendant's person and the holster found in the girlfriend's pocket, in addition to the spent casings found on the scene. So that was evidence, regardless of the actual finding of the gun, that supported the prohibited use of a weapon, specifically the 1911. And of course, that it was undisputed, because you can see it on the video, that the defendant was in possession of the revolver, which he conceded.
So why is it harmless beyond a reasonable doubt with respect to the 1911? Because it was specifically charged as a 1911.
Yes, there were two guns.
And I mean, why can we conclude that? Because we would have to conclude it's harmless beyond a reasonable doubt,
yes,
right?
Yes.
Why doesn't that charge create an obstacle to finding it harmless as to all the charges? There's at least one charge that it wasn't harmless. The introduction of that evidence wasn't harmless beyond a reasonable doubt.
It wasn't, because you have at least two witnesses who said it was a 1911 gun, and you have other circumstantial evidence kind of proving that he had that gun, the magazines, in addition to the holster that the girlfriend had, and the spent casings found on the scene consistent with the 1911. So that, to me, makes any error harmless beyond a reasonable doubt. And, I'm not going to argue, or the prosecution said that, and the police were already working on a search warrant at the time of the alleged illegality, which, again, would do under the inevitable discovery, or the other one that I always get confused, would apply. So again, all that and all the other evidence makes any error, which again, it was an error, but
Right.
any error was harmless. And you don't even have to decide the Buick thing, find the error harmless, and if this court decides to rule on the merits, find that the court's findings are supported by the record and the law.
Okay, very good. Thank you.
Thank you very much, and for this extra time.
You're welcome.
And of course, we request that defendant's convictions be affirmed.
Very
Thank
good.
you.
And Mr. Steinberg, I'll give you 1 minute.
Thank you. The inevitable discovery doesn't work, because them working on the search warrant, if the court reviews the search warrant, you'll see it's replete with the fruits of that search. Two, I would urge the court to review our opening brief at pages 9, 10, and 11. We have the factual renditions that the court has been asking about in terms of what Bach knew, what Bach said, and what he was told. And finally, I guess the best point I have in terms of emphasizing to you that this was a search for evidence is, as set forth in the record, after doing the so-called protective sweep, the second one we would argue, he walked through the house again with Bach to point out the items he had seen. What right do they have to go back into the house and point out the items other than it's been a search? And what this is, it's a thin line, and I get that. The thin line is the evidence that may support the protective sweep is also a search for evidence. Let's be honest. And that's why this case is so tricky, because all the things you point to is, we got to go find the gun. Well, maybe we go find the shooter. It's a search for evidence. It's not a protective sweep. And the bottom line is, how do you say it's a protective sweep when you have 10 officers running around the house before you do the sweep? Thank you so much.
Very good. Thank you, counsel. Appreciate the argument as well as the briefing on this case. The case will stand submitted and a written opinion will issue in due course. And that brings our afternoon docket to an end, and we will be in recess if the bailiff will so announce.